Good morning, honorable members and our stakeholders. You're welcome.
Good morning.
Morning.
Morning, Charlotte.
Morning, Honorable Mahlangu. You're welcome, and all our stakeholders.
Thank you, Madam. Good morning to all honorable members and officials.
I do not hear anything. Has the meeting started?
Good morning, Honorable Weber. You are all welcome. We're just waiting for other members to join and we'll start our meeting in 5 minutes' time. Thank you.
Okay, thank you very much.
Morning once again, honorable members and all the speakers are requested to switch on their cameras when they are on the platforms because we are streaming live on Facebook and YouTube. Thank you.
Hello, good morning.
Good morning, Honorable Mlombo.
Good morning. How are you?
We are good. The platform is yours. You can proceed. Thank you.
Okay. Good morning to the honorable members. I have seen the honorable MEC have joined. Good morning to our support staff. And I'm told that there are a number of stakeholders that have joined. Good morning to all of them. We will get to know each one of them as we proceed with the meeting. I have been struggling to join. The network where I am is not that much very good. I've been struggling. I would struggle until the end of this meeting, but I will try my level best that we are together. I want to officially declare this meeting open. The purpose is to get a presentation on the titles, on the sectoral titles amendment bill. We will get a presentation by the Department of Agriculture. We'll get the attorneys to also say, we'll get inputs immediately after that. And they will get our legal advisors to come in, and then immediately after that would allow responses. I'm told that the Department of Agriculture is ready to do a presentation in terms of this public hearing. So with those few words, let me take this opportunity to officially welcome all of you to this public hearing. And I believe that would all accordingly participate to ensure that each and every input is taken care of, and so that we are able to process this bill. Thank you very much. You are all welcome. I would move to item 2. Charlotte, I want to believe item 2 is apologies. Are there any apologies?
Thank you, Honorable Mlombo. We've received apologies from Honorable Makarenge, Honorable Krobla, who are attending the APEC conference in Durban. Thank you.
Okay, thank you very much. Honorable members, those are the 2 apologies from the 2 honorable members. Is there any mover for the acceptance of the apologies?
Thank you, Chief Matlango. I move that we accept the apologies as presented.
Thank you very much.
Rovia Morgan, I second.
Okay, thank you very much. The apologies have been moved and seconded. Let's move to the next item on the agenda. Charlotte? Charlotte, you have removed the agenda from the screen. I want to believe the next item on the agenda is the presentation.
Yes, Honorable Chair.
Okay. If the next item on the agenda is the presentation, I want to take this opportunity now to welcome and invite the Department of Agriculture. I would invite the Honorable MEC to indicate as to who is going to do the presentation. And I want to believe she would like to make a few remarks before she allows whoever has been delegated to do the presentation. Thank you very much. Honorable MEC, MEC Shiva.
Thank you very much, Honorable Chairperson of the city. I'm not so sure whether I'm audible. I'm also challenged by the network, hoping that you are hearing me. Let me take this opportunity and greet you as well as honorable members and all the stakeholders that are here, as well as the staff both from the Department of DARC, as well as from the legislature and from the municipality. Chair, let me take this opportunity and also to thank the Portfolio Committee for inviting us on this important meeting where to go through the Sectional Titles Amendment Bill of 2020. Honourable members, in our midst, we have representatives from the National Office, the Department of Agriculture, Land Reform and Rural Development. They are here and they will take us through the 17 clauses. Chair, Mr. Rendani is also here with us. He will take us through Chair, and that, as per the norm, stakeholders will deliberate on the input after the presentation. Thank you very much, Honourable Chair. Over to you, Mr. Rendani.
Good morning, honorable members, MEC, and ladies and gentlemen. My name is Rendani Mkakululi. Then, as MEC has indicated, then today, I'm with Mr. George Tsotsotezi and also Antoinette Reynolds. And then Antoinette Reynolds is the one who's be doing the presentation of the Sectional Title Amendment Bill today. And then I'll hand over to Antoinette to take us through to those 17 clauses. Thank you.
Good morning, Chair and all members. I'm Antoinette Reynolds. The network quality here in Pretoria is not very fantastic. Voices disappear every now and then, but I'll start the presentation. It's a very lengthy presentation, 37 slides, so I'll try to be as brief as possible. So the Sectional Titles Act, as an introduction, we can mention that the Sectional Titles Act, that's Act 95 of 1986, provides for the acquisition of full ownership and parts of buildings, that's your sections, coupled with joint ownership and common property. And the common property comprised of land by the scheme, and that is not part of the building and is not included in a section. It also provides for the acquisition of real rights over common property, such as exclusive use areas, for example, parking bays, gardens, etc. So for those that's not familiar with sectional titles, here we think of your big shopping centres, office blocks, townhouses, etc. That is, for instance, where you are the owner of a townhouse that is registered in your name, and together with all the other owners in that townhouse scheme, you joint ownership in the common property. And with common property, we're thinking of your gardens, tennis courts, driveways, etc. So the Sectional Titles Act also, it legislates mainly on surveying matters. That is the approval of sectional plans by the Surveyor General, as well as registration matters by the Registrar of Deeds, the deeds officers. They attend to the opening of sectional title scheme, the registration of the sectional plan, registration of transfer of ownership in the units, etc. So the Sectional Titles Act does not deal with matters pertaining to the management of schemes and the dealings with dispute resolution matters. Those matters are dealt with by other legislation. Now, the management of schemes are dealt with by the Sectional Title Schemes Management Act. That's Act 8 of 2011, and that act is being administered by the Department of Human Settlements. Now, this act provides, amongst others, for the establishment of bodies corporate, and those body corporates then, of course, manage and regulate sectional title schemes. And for that purpose, they apply rules. This act also provides for the rules to be approved and to be filed and amended and substituted by the Office of the Chief Ombud. And this act also then provides for the establishment of a Sectional Title Schemes Management Advisory Council, which attend to the administration of that act. Now, matters that deals with dispute resolution mechanisms that are addressed by the Community Schemes Ombud Service and also not by the Sectional Titles Act. I thought we'll just mention that quickly because people are sometimes under the impression that the Sectional Titles Act and that our department deals with those issues. Now, the objects of the Sectional Titles Amendment Bill is to amend certain provisions of the Sectional Titles Act for the purpose of improving and enhancing the application and the implementation of that Act. So Clause 1 of the Act deals with the amendment of Section 1, and Section 1 deals with the definitions. Now, the definition of exclusive use area means a part of the common property for the exclusive use by an owner or owners of one or more sections. And this definition is to be amended to include an occupant or occupants that are recognized by law, to also make it clear that those occupants can also use the exclusive use areas. And it will protect the rights of occupants, such as the lessees of the sections, to also legally use the allocated exclusive use areas. The definition of Sectional Title Schemes Management Act is currently incorrectly reflected in the Sectional Titles Act as being Section or Act 8 of 2010 instead of Act 8 of 2011. So that definition will be amended just to correct the correct legal position. Then Clause 2 of the Act deals, or Clause 2 of the bill deals with the amendment of Section 4 of the Act. And Section 4 deals with the approval of development schemes. And it provides for developers to have certain meetings with lessees where a part of a building is wholly or partially let for residential purposes. And these meetings are then held with lessees to inform them about their rights. And it may currently those meetings may only be attended to by lessees. So there's a need to amend the Act to provide also for a lessee's representative to attend such meetings in instances where a lessee is, for instance, not in a position to attend, or where such a lessee wants to appoint a person with a knowledgeable person to attend the meeting on their behalf and to ask the relevant question to the developer. So the amendment is basically just to protect the rights of lessees. Clause 3 of the bill deals with the amendment of Section 14 of the Act. Section 14 deals with the amendment and cancellation of sectional plans by the Surveyor General. So where a unit is incorrectly reflected on a sectional plan, and it is in the opinion of the surveyor that a person may be prejudiced by such an incorrect sectional plan, that Surveyor General may then advise the registrar as to which sections on the sectional plan is affected, and thereafter no transactions in respect of such section shall be registered until the defect in the sectional plan has been rectified. So the registrar will then note caveats against the further dealings with those sections until the sectional plan has been amended by the Office of the Surveyor General. So this amendment will now also include exclusive use areas that are incorrectly reflected on those sectional plans. So the principles that are now applicable to sections will then also be applicable to exclusive use areas. So Clause 3 also deals with the amendment of Section 14.8. And so far, the Act currently provides procedures to the developers in instances where the court issues an order for the cancellation of a sectional plan, but there's no provisions in place that a body corporate needs to be followed where the court issues such an order for a cancellation of the plan. So the effect now is just to create the necessary administrative certainty with regard to the procedures that must be followed by a body corporate and those that must be followed by a developer where a court issues a cancellation order. Clause 5 deals with the amendment of Section 17 of the Act, and Section 17 deals with the alienation and the letting of common property. And this clause provides for 3 amendments. So to those that's not familiar with sectional titles, you'll sometimes find next to a shopping centre is a vacant piece of land. And it may be that that vacant piece of land is a part of the common property of the sectional title a scheme over which the developer or the body corporate has a right to extend in the next phase that shopping centre or that block of townhouses to build more shops or townhouses or what the case may be. So Section 17.4b of the Act currently stipulates that where the body corporate wishes to lease land, to let land or part of land, to let a part of that common property in the scheme on which a section or part of a section is erected, that the lease agreement of that common property area must be made subjected to the right of the owner of the section that has affected. So the Act is now being amended to also provide that that lease agreement must also be made subjected to the rights of holders of exclusive use areas and the rights of holders of rights to extend the scheme in terms of Section 25. So those rights must also be included in the lease agreement so that the lease agreement is then subjected to the rights of the owner of the section as well as the rights of holders of exclusive use areas and rights of extension of the scheme. Now, Clause 5 also provides for the amendment of Section 17.4 capital B that deals with the alienation, the transferring of a portion of the common property on which an exclusive use area is situated. So the current position is where an exclusive use area or a part of such an exclusive use area is situated on a portion of that land or that common property that is to be alienated, that the registration of such exclusive use area or part of such an exclusive use area must be cancelled. However, the Sectional Title Act doesn't deal with only portions or parts of exclusive use areas, and Section 17.4b is now being amended to make it clear that the registration of the whole exclusive use area must be cancelled and not only a part of the exclusive use area. Now, Section 17.4c of the Act that deals with the alienation of a portion of a common property on which a real right of extension is registered is also being amended. And this is just a consequential amendment to the amendment of Section 17.4b. However, Section 17.4c is retaining the provisions regarding the cancellation of only a part of the right of extension, while 17.4c then provides for the cancellation of the whole of the exclusive use area. Then Clause 6 of the Act deals with the amendment of Section 18. Now, Section 18 deals with the transfer of mortgaged units and the cession of mortgaged leases and cession of mortgaged real rights. And Section 18 makes the provisions of Section 56 and 57 of the Deeds Registries Act applicable, insofar that bonds that are registered over these properties must be disposed of. Those bonds, for instance, when you transfer a unit, the bond, and there's a bond registered over that unit, then this Act makes provision that a bond must first be cancelled, or the property must be released from the operation of the bond prior to the transfer of that unit. So the cancellation of a section and of an exclusive use area, as contemplated in Section 17 in the previous two slides that I've talked to, has the effect of the alienation and in Section 18. And Section 18 now needs to be amended also to provide that the bonds that are registered over those sections or exclusive use areas on that common property, that, as I said, that needs to be cancelled, that those bonds that are registered over the section and the exclusive use area must also be disposed of in the event of the cancellation of a unit or of the cancellation of an exclusive use area as contemplated in Section 17 of the Act. Then Clause 7 of the Act deals with the amendment of Section 21 Now, Section 21 deals with the approval of plans of consolidation and the approval of plans of a subdivision by a surveyor general, by the Office of the Surveyor General. So this is, for instance, where you have two smaller flats and you want to consolidate into one bigger flat, or you have one bigger one that you want to subdivide into two smaller ones. You can ask a land surveyor or an architect to draft the necessary plan of subdivision or of consolidation, and you can lodge it then with the Surveyor General for approval. Now, there's a need to also provide for these provisions to also apply to a developer, where a developer, prior to the establishment of a body corporate, wants to subdivide a section or to consolidate a section. So the effect of the insertion of Section 1A is also just to make these provisions also to the availability of a developer to have those plans lodged to a Surveyor General for approval. Now, Clause 8 deals with the amendment of Section 22, and Section 22 deals with the registration of a subdivision of a section. Now, while Section 22 deals with the approval of those plans by a Surveyor General, Section 22 now provides for the registration of those plans and those deeds pertaining to the registration of the subdivision of the sections. So the insertion of Section 22(1)(a) is consequential to the amendment of Section 21, and it provides also then for the developers to apply to the Register of Deeds for the registration of that sectional plan of subdivision and for the registration of those deeds relating to the registration of the subdivision. Now, Section 22(2) provides for certain deeds and documents to be lodged with a Registrar of Deeds. For instance, the title deed of the section, any bonds registered over that section needs to be lodged in order for the Registrar of Deeds to do the necessary endorsements on those deeds to reflect the position that this section has now been subdivided. And Section 22(2)(ca) is now being inserted to also provide for the title deed of any lease agreement or the title deed of real rights over that section to also be lodged to the Registrar of Deeds for endorsement. And the amendment also provides for the lodgement of an affidavit to the effect if the deeds are lost, that an affidavit can be lodged, and the Registrar of Deeds will then, of course, endorse the office copies of those deeds. Now, Clause 8 also provides for Section 22(2)(d) to be amended to rectify the position, namely that in the event of a subdivision of a section upon a participation agreement between two or more co-owners, each certificate of registered sectional title must be issued in the name of all the co-owners. So the subdivision must first be registered, and then after the participation agreement must be registered after the subdivision agreement. And there are no other documents or particulars prescribed in the regulation, and therefore Section 22(2)(e), as currently stand in the Act, must be deleted. Then Clause 8 also provides the purpose of the insertion of Section 22(2)(a) as merely to protect the rights of purchasers of units who have not yet taken transfer of those units at the time when the developer applies for the registration of a sectional plan of subdivision. So the deed of alienation in which a subdivision has not been disclosed shall then be voidable at the option of the purchaser. So the inclusion of 22(2)(a) is to protect the rights of purchasers. Then Clause 9 of the Act deals with the amendment of Section 23, and Section 23 deals with the registration of a consolidation of sections. So these amendments are exactly the same as those discussed under Clause 8. The first one is the insertion of 23(1)(a), consequential to the amendment of 21, and it merely provides also now for the developer, prior to the establishment of the body corporate, to also apply to the Registrar of Deeds for the registration of that sectional plan of consolidation. 23(2)(ca) then also provides now for the title deed of the lease agreement and other title deeds of real right that's registered over the section to be lodged with the Registrar of Deeds for purposes of endorsement. And then, of course, the purpose of the insertion of 22 or 23(2)(a) is also again to protect the rights of purchasers who have not yet taken transfer at the time when the developer applies for the registration of a sectional plan. And the deed of alienation, of course, must contain that consolidation must be disclosed in that deed of alienation. Otherwise, the purchaser will have the right, in terms of this clause, then to cancel that alienation deed, that sale agreement. Clause 10 deals with the amendment of Section 24, which deals with the extension of a section when an owner of a section wants to extend the boundaries of the sections. So the nature of the amendment of section of Clause 10 and that deals with the amendment to Section 25 is exactly the same as I now explained in Clauses 8 and 9. It's exactly the same amendments. Then Clause 8 or 11 deals with the amendment of Section 25 of the Act, and Section 25 deals with the extension of a scheme. And there are six amendments in Clause 11. The first is the insertion of Section 25(2)(a), and the insertion of this section provides for a replacement of lost or destroyed documents as contemplated in Section 25(2)(a), B, C, D, or G. Those are, for instance, your building plans, your block plans, etc. So if those plans are lost or destroyed in the deeds registry, Section 25(2)(a) now contains provisions that must be followed for replacement documents then to be lost, to be lodged in a deeds office. And the amendment of Section 25(5) A, sub A, is to make the provisions of that section applicable to the extension of a scheme by the addition of exclusive use areas. So currently it only is applicable to the extension of a scheme by the addition of sections, and it's now also when exclusive use areas are to be added. So it will make provision that the application for the registration of a sectional plan of extension must then be made immediately after the completion of the unit and also after completion of the exclusive use areas. Then Section 25(6) deals with the vesting in a body corporate of a right to extend a scheme in certain circumstances. And it also contains the provisions that must be followed by a body corporate in obtaining a certificate of real right and of extension of the scheme. So the amendment of Section 25(6) in Clause 11C of the bill, this amendment has the effect of restricting a body corporate from alienating or transfer that right of extension without the consent of the bondholders and without the consent of the holders of real rights over units and real rights, other real rights over the scheme. So the body corporate will first have to have the consents of those bondholders and holders of real rights prior to the body corporate then being in a position of alienating and transferring that right of extension. Then Clause 11 also provides for the substitution of and the amendment, of course, of Section 25(10)(c) and 25(10)(d)(a), and that seeks to eliminate the duplication regarding the lodgement and the endorsement of mortgage bonds. So there's just a duplication in those two sections, which is now being amended. I just want to take a sip of water. Clause 12 deals with the amendment of Section 26 of the Act. And Section 26 currently makes the provisions of the extension of schemes by the body corporate, Section 26 makes provision for the extension of a scheme by the body corporate. So the body corporate can purchase and acquire more land to extend the boundaries of the scheme. So the addition of section 26.8 will also now provide for developers prior to the establishment of the body corporate. It will also now make it possible for developers to acquire that land to extend the scheme. And the protection afforded to purchasers, as I mentioned, under clauses 8, 9, and 10, where they can, where the deed of sale is not, where this right to extend the scheme is not mentioned in the deed of sale, then it will be voidable at the option of the purchasers. Then clause 13 deals with the amendment of section 27.5. Section 27.5 currently provides for the cancellation of a right to an exclusive use area by means of the registration by the Registrar of Deeds of a notarial deed that is entered into by the holder of such right to exclusive use area, as well as the body corporate needs to enter into that notarial deed. Now, the insertion of section 27.5 capital A enables a developer to cancel a right to exclusive use area by means of the registration of a unilateral notarial deed of cancellation. So where there is no body corporate in existence, then the developer will then be able to cancel the right to exclusive use area by the registration of a unilateral notarial deed of cancellation. Clause 14 seeks to amend section 32 of the Act, which deals with participation quotas. This Act incorrectly refers to a certain section in the Sectional Titles Act instead of a section as in the Sectional Title Schemes Management Act. So it will just correct the correct legal position. Clause 15 deals with the amendment of section 54 of the Act. Now, section 54 deals with the establishment and duties of a Sectional Titles Regulation Board. So the section is being amended to substitute a reference to the Law Society of South Africa and to replace it with the South African Legal Practice Council. And the amendment is necessary in view of the enactment of the Legal Practice Act, Act 8 of 2014. Now, the amendment also will remove the requirement of 2 persons that have special knowledge on sectional title schemes to be members of the Sectional Titles Regulation Board. And as I mentioned, the Sectional Title Schemes Management Act does provide for a Sectional Title Schemes Management Advisory Council. So these members will be absorbed by that council. The amendment also provides for the number of conveyances to be 2 members instead of 1 member. So there will be an extra conveyancer to be a member of the board. It will also provide for a Registrar of Deeds to be a board member, and it will also make provisions for the provisions of that applies to board members to also be applicable to alternate members of the board. Then clause 16 seeks to insert 55.2 into the Act that deals with regulations and will provide for regulations to be published in a government gazette at least 1 month prior to the commencement of the regulations. And this amendment will then align with the provisions of Section 9 of the Deeds Registries Act that provides for the regulations at least 1 month before commencement thereof, the Deeds Registries Regulations. So it will be in alignment with Section 9 of the Deeds Registries Act. And that's the end of the presentation. Thank you, Chair.
Thank you very much. Thank you very much for a well-presented presentation and very informative presentation. Thank you very much, Antoinette. And because I was rushing when I opened the meeting, I forgot to introduce myself. My name is Fidel Mlombo. I'm a member of this committee. In the absence of the chairperson, I am presiding over the meeting. Now I would take this opportunity to allow our stakeholders. I'm told that we've got a lot of stakeholders, the City of Mbombela, the Lawyers Association, the conveyances, and many of others. I'll now take this opportunity to allow them an opportunity to make comments, to ask questions for clarity, and we'll take it from there. Thank you very much. I will pause now and allow stakeholders to come in. You can raise your hand using the system, or you can just shout. I'll allow you to speak. Is there anyone who wants to speak? We've got
Chair.
Yes, Charlotte?
Is Deputy Speaker.
Okay. Deputy Speaker.
I say it will be workable if
Hi, Deputy Speaker, you're cutting. I can no longer hear you.
Did you get my point, Chief Whip?
No. If you can please repeat it, Deputy Speaker.
I say it will be workable if the coordinator give you the list, then you will call them by the list, so that if the person is not available, you just pass, than to say anyone who want to speak.
Okay. I do not have the list as I indicated. I've got the connectivity challenge, but I would now allow the City of Mbombela to come in if they want to say something. I see here there is a Mr. Kutie from the City of Mbombela.
Yeah, thanks, Chair, and greetings to honourable members and the MEC. I've got a question pertaining to SPLUMA alignment. With the implementation of the Spatial Planning and Land Use Management Act, the Surveyor General's Office indicated to the municipality that because of the SPLUMA Act and the municipal bylaws, approval from the local authority is required for sectional title plans and amendments to sectional title plans before it can be considered by the Surveyor General's Office. As an interim arrangement, the SG's office accepted the approval letter of building plans from the municipality for structures where sectional title schemes and scheme plans are to be approved. My question is this matter still relevant, and should it not be addressed in this amendment? Thank you.
Thank you very much. Both the presenter and her colleagues, they will jot down the questions. I will allow them to respond after each and every stakeholder have asked for a question or has made a comment. I'll now allow the conveyancers, yes, to anyone who's representing the conveyancers to come in and make a comment or ask a question. If there is none, I'll move to the Lawyers Association, the attorneys. Is there anyone who wants to ask a question or comment? Okay, let me go back again and say, because I now cannot see who is here in terms of your organizations. can you please shout? If you are here, you are a stakeholder, and you have got nothing to say, just shout and say nothing to say. If you've got something to say, just shout and ask whatever question that you want to ask.
Hey, good morning. My name is Nick van der Merwe, Governor Mbeki Municipality. Can I continue?
Yes. Thank you very much. You're welcome. You can continue.
Thank you, Chair. I want to concur with Mbombela on that issue of Spluma, but want to take it one step further to indicate that we must use this opportunity of the amendment of the Sectional Titles Act to put into place also the municipality's approval to such subdivisions, consolidations or changes. For too many or for too long have municipalities been bypassed on technical matters, and sometimes also due to lack of capacity in municipalities, not commenting on changes of a sectional scheme. My submission, therefore, is that we take this opportunity to make it clear that any such amendment to a scheme or even the registration of such a scheme should be approved by the municipality, because in line with Spluma, which makes planning matters part of the space of municipalities, Spluma should be acknowledged in this regard. Thank you, Chair.
Okay, thank you very much for your comment. Can I allow another stakeholder? In case you are here and you've got nothing to say, please make it clear to us that you are here and you have nothing to ask or comment. Is there anyone who wants to say something? I will count to 3 and then I will close this section of asking for comment. I'm counting 1, 2, 3. Okay, no, that's fine. Stakeholders, we're done with them. And now I'll go to honorable members. If there is anyone who wants to comment or ask a question. Honorable members? Honorable Deputy Speaker, I did not welcome you earlier, but you are welcome, Deputy Speaker, and thank you very much for the directive that you gave us. Thank you. Honorable members, it's your opportunity now.
Thank you, Honorable Chief Whip. I don't have anything to comment as Deputy Speaker.
Okay, thank you very much, Deputy Speaker. Honorable Weber.
Chairperson, this is legal stuff. I don't think that I should risk to comment here because you will easily see that I am completely out of my depth here. Thank you.
No, thank you very much. You don't want to expose yourself because this is to deal on legal issues or with legal issues. Honorable Javier Morgan.
Thank you, Honorable Chief Whip. I'm fine. I'm covered.
Okay.
Thanks.
Is there any
I feel
other
like Weber. I don't want to deal where I can't.
You don't want to expose yourself. Honorable
Exactly.
Thank you, Honorable Chief Whip. Thank you, Honorable Chief Whip. I welcome the report.
Okay, thank you very much. Let's now give to
Honorable Chief.
Hello. Oh, Honorable Kabela.
Yes, Chief Whip. I'm also covered.
You are also covered, ne?
Yes.
I hope there's no one I'm leaving behind now. We all have been given an opportunity. Can I allow our presenters to respond, Antoinette and your colleagues.
Thank you, Chair.
Hello.
Thank you. I'm back. The City of Mbombela and Mr. Nick van Merwe, I couldn't hear everything, but it sounded as if they have problems with the alignment with the Spluma Act, and that municipalities are bypassed with the amendment of schemes, and so far the Spluma provisions are not always complied with. All that I can say in this regard is that the Sectional Titles Act deals with the approval of draft sectional plans by the Surveyor General. And in accordance to the Act, all those provisions of the Spluma Act must be complied with prior to the approval of such plan by the Surveyor General. And the Registrar of Deeds shall not register such a plan unless all those provisions have been complied with. So the Act is clear, and so far all legislation of Splumas must be complied with prior even to the approval of such plans by the Surveyor General, and thereof the registration by the Registrar of Deeds. I just want to say we have in the past had extensive consultations during with the Law Society, Mr. Gaga, who is representing the LPC. So we have before had lengthy discussions on the bill, and maybe that is also why there is not a lot of questions now from the conveyances side. And also I can just mention that there is the memorandum on the objects of the bill, which is attached. When you go through the bill, right after the bill, you'll find the memorandum on the objects of the bill, and it clearly explains the reason for each amendment. And maybe that's also why there is not a lot of questions today, that members maybe have worked through that document. But that's all from my side. Thank you, Chair.
Okay, thank you very much. Is there any other follow-up from the side of the department, the presenters? If none.
Good morning, Chairperson. I think you didn't see my hand. My name again is George Sotetse. What I can commit on this platform is to say that the issues that have been raised by the City of Mbombela as well as the Govenbeki municipality have been noted, and we will engage our colleagues in the surveying fraternity so that we can discuss these matters further. Thank you, Chairperson.
Okay, thank you very much. Thank you very much. Thank you very much for all the comments and, in fact, your responses. Let me now allow our legal advisors, the legal department, to come and say a few words with regard to the sectoral amendment bill.
Honorable Chief, good morning.
Mr. Mlombo, before you comment, can I please put a comment from the Office of the Surveyor General?
Okay. I thought I'm done with the stakeholders, but let me allow you an opportunity before I allow our legal department. Surveyor General, you are an important stakeholder. Yes, thank you.
Yes. I hear our colleagues from Govenbeki and Mbombela talking about their lack of capacity in terms of the approvals for the consents to do the subdivisions and their consolidations. I think it would not be possible to align this amendment bill with that requirement, because also Section 33 of the Spluma Act says that the municipality is the authority of first instance in all land development matters. So for us, we will not be able to approve any plan of amendment without you complying with the municipal requirements. So as much as we sympathize with them that it's tedious and it's a lot of work, but it's a requirement of law. Thank you.
Okay. Okay, thank you very much. I'm not sure whether there is a counter response from the two municipalities. But be that as it may, there will still be continuous engagement on this bill. There's still a long process. I will deal with that process when I'm about to close. But also, if there are further comments, we can also do submissions in writing. So, yeah.
Thank you,
in view
Chair,
of that.
Okay, Chair, now
okay, let me allow an opportunity. Is Mr. Kutia?
Nick van der Merwe, again, Governor Mbeki Municipality. I take note of the comments as well as the two inputs from Survey General's office, and we'll engage on that matter further. Thank you.
Yes, like I have indicated, there is still enough time to engage on this matter. Let me allow the legal department to come in and give us a legal advice.
Chair, thank you so much. Honorable members, good morning. Is it good morning? Yes, good morning, and good morning all stakeholders. My name is Advocate Tabang Sweta. I'm Manager Legal Services from Mpumalanga Provincial Legislature. Chairperson, deliberations and discussion has taken place, and in particular about SPLUMA and what is the role of local municipality, and in terms of all the processes that are there. Chair, as legal services where we are saying let all stakeholders make submissions to the legislature in writing, make those submissions so that when we deliberate, honorable members would have all those documents that are there at their disposal. Then we can be able to sit down and advise correctly on the way forward. How it's going to be? Tomorrow morning, there's going to be at the municipality. There's going to be a public hearing that will also deal with these matters, because it is the in terms of the constitution and legislation, we are supposed to go to almost every district for everyone, the public, to make submissions. And secondly, Chair, after we have received all submissions and documents, we are going to sit down and look at the report. And when we look at the report, it's with an understanding that we'll have to prepare what is going to be termed and negotiating mandates. So when that process comes, when we deal with negotiating mandates, it is only when honorable members will be able to sit down and vote whether we accept the bill with amendments or further amendments, because this is an amendment, further amendments, and we look at the compliance in terms of the constitution, in terms of all other legislation that is there. So, Chairperson, will be waiting after the last public hearing tomorrow for another meeting where we'll sit down, look at all documents, sit down, make further improvements, make further amendments, and look at it and how they comply with the legislation. Then prepare a negotiating mandate. And this is our submission, Chair. This is a very good amendment to the legislation, because the legislation at all material times has to be improved, has to be updated, but has to comply with constitution or any legislation or court decisions that are there. And that's our submissions in terms of legal services, Chair. Thank you so much.
Thank you very much. Thank you very much, Advocate. You are also doing a way forward, because I'm about to close now. Thank you very much for your contribution. As a matter of way forward, summary and way forward, this is the third public hearing that we are conducting. We've conducted two already in the two districts, which is Ehlanzeni and Sibande. Tomorrow, like the advocate have said, we will be in Stiftjete covering the third district. So we will have we would have done 4 public hearings, including this one. We have also interacted with the various media platforms, your newspapers, your print media, your electronic media, the different radio stations in the province, interacting with the public with regards to this bill. We are happy that we have received very warm responses from the public. They have had their comments, but in overall, they were giving their support and blessing for us to continue with the processes that the advocate has indicated, putting our position as Mpumalanga in the National Council of Provinces, where we will be invited to go and put our position as Mpumalanga as to where do we stand with the bill. So we want to thank you. We want to thank you for your participation and all your comments. They would be taken into consideration in the process as we move towards the finalization of this bill, because we believe that this bill is making things easier for the members of the public who are participating in that sector, so that they have broader activism and broader participation in the day-to-day running of the sector that is being covered by the bill. I would now take this opportunity to thank all of you and to thank the Honorable MEC for always availing herself when we are dealing with this bill. I note with appreciation that in all the public hearings that we have held, she has always been consistently there with her delegation, well prepared to engage on all the matters that are before the meeting. But also to thank the entire delegation that comes with the Honorable MEC from the provincial department to the national department. To thank all the stakeholders that are here who have actively participated. We take your comments into consideration. We take them very seriously. And to thank our support staff who always make it possible for us to hold this meeting. And to thank our legal department, the advocates. They are always there to guide honorable members in terms of our day-to-day engagement. And lastly, to thank the honorable members for always availing themselves. I know that Honorable Mahlangu is not well, but despite the fact that she's not well, she has made sure that she's part of this meeting. That commitment is appreciated by ourselves. And yes, it is appreciated by ourselves. And yes, with those few words, I have been dealing with item 6 and item 7. I would now like to take this opportunity to wish you well in terms of your other commitments throughout the day, and to wish those who will be traveling from wherever you have connected, safe journey back home. Thank you very much. From my side, this should be the end of the meeting. Thank you very much. The meeting is accordingly closed. Thank you.
Thank you, Chair.
Thank you very much. Thank you very much.